a todo el mundo y bienvenido a mi canal. Yo me llamo Sirey. Soy una abogada afro-latina licenciada practicando la ley de criminales, pero como todos ustedes, a mí me fascina cuando estamos hablando de casos de crímenes reales. En este video vamos a continuar hablando de Karmelo Anthony. Si quieren más video en español, nada más dime allá abajo. Hi everyone and welcome back to my channel. My name is Desiree. I'm a licensed and practicing Afro-Latino criminal attorney who, much like the rest of you, has a severe fascination with true crime cases. Listen, you guys, let's go ahead and continue our coverage into this 1,000,000-page document that was filed by Karmelo's appeal team. I'm going to continue the coverage because you guys might find it fascinating. But at some point, I'm going to just completely end the coverage unless you guys tell me otherwise. But let's go ahead and get started in our continued coverage on the case of Karmelo Anthony.
New development in Karmelo Anthony's upcoming appeal. A camera will be allowed in the courtroom for a hearing on whether Collin County Judge John Roach should be recused. And we've learned there will be an overflow room to allow more spectators. Cameras weren't allowed during Anthony's murder trial for killing Austin Metcalf 2 years ago at a track meet in Frisco. Anthony hired a new defense team after being convicted in June. The recusal hearing will take place August 19th, and a judge will hear their motion for a new trial the next day.
In actual operation, public access was even more restricted than the order's text provided. The deficiencies in the order's text were compounded by the way the access regime operated in practice. Because the closure is assessed on the totality of the evidence, the actual operation of the regime is properly before the court. The affidavit of Thelma Anderson, a member of the public who repeatedly sought to attend the trial, establishes that the regime operated more restrictively than its text provided, and that a reasonable alternative was not merely overlooked, but affirmatively withdrawn. Those facts compound the deficiencies apparent on the order's face. They do not supplant them. Consistent with Cameron and Lilly, the closure is established on the totality of the evidence, and the defendant need not show that any particular member of the public was excluded.
But now headed for closing arguments in the case of Karmelo Anthony, the young man who was charged with murder in Collin County, Texas. The defense today rested without calling Karmelo to testify. Of course, he is on trial for the murder of a white teen that took place at a track meet there in Collin County. The all-white jury of 11 women and 7 men, they will decide the fate of this black teen. Joining us tomorrow, again, closing arguments will begin on tomorrow. A legal analyst, Thelma Anderson, has been in Collin County following this trial. And so get us up to date. Thelma, Saturday, the trial took place on Saturday. And then, of course, you had the defense taking over and today. So let's talk about what took place on Saturday, and then let's talk about what happened today. The prosecution continued advancing their case on Saturday. What took place?
Absolutely. On Saturday, the state called their final witness, one of their final witnesses, which was the young man who invited Karmelo into the tent. So they called, I think his name is Eddie Para. He's a student at Memorial with the brothers Hunter and Austin. So they called him, and it was a very explosive day because he got on that stand and he completely denied that he knew Karmelo. And it was very weird that the state would allow one of their main witnesses to get on the stand and discredit themselves and allow the defense to come in and ruin their credibility by showing actual pictures of him and Karmelo at friend gatherings, at family gatherings. And he got on that stand and denied that he even knew Karmelo, which was very explosive and very bad for the state.
With that, right. Okay, go ahead.
That was one of the pivotal moments that happened on the state side. And then they ended up resting right after the defense completely ruined his credibility. And so once they rested, then the defense started their case, which the defense ended up calling a state witness who the state decided not to call, because once we heard his testimony, it was very clear he brought too much truth to the credibility of Karmelo as to why the state decided not to call this individual who was actually sitting right there, saw everything, and is the one that gave the police officers the statement that Karmelo was invited into the tent. Karmelo was not aggressive. Hunter was the aggressive one. Austin then reciprocated the energy of his brother, as well as he said something that was very damaging, which was Austin was substantially bigger than Karmelo, who was sitting down the entire time, which adds to the proportion of weight classes of when a person is deciding, okay, this person is bigger than me. I cannot take them. I'm in fear of my life. I'm going to have to use force necessary to defend myself. So that's pretty much what happened on Saturday that now trickled over till today, Monday.
Okay, so how many witnesses did Karmelo's defense team call today?
They called a total of 3.
They called a total of 3 witnesses. And so you talked about
3 witnesses.
One of those witnesses were the state witnesses. One of those witnesses was the state witness. Who were the other 2 witnesses?
The other 2, so one was a state witness. Well, 2 of them was a state witness. We had an officer, and we had one of Karmelo's teammates that gave a statement. And then we had an individual who wouldn't be considered a state witness because he was a student at a different school, but he was there during a track meet and actually saw a physical altercation take place.
All right. And so then they chose to rest. Now they head to closing arguments. And so, clearly the state believes that they've made their case. Are you surprised that Karmelo's defense team only called 3 witnesses?
I'm not surprised because, as I've stated from the inception, the burden to meet each and every element is on the state, and it never shifts, even in a self-defense claim. I can tell you that throughout this particular trial, the inconsistencies from these state's witnesses was very strange, is that the defense wasn't even calling their witnesses. The state called them in order to bring out even more truth that the state, I feel like, was trying to bury in the inconsistencies to pretty much confuse the jury. I'm like, why would you risk this type of trial with such weak evidence and such weak, inconsistent statements that were not reliable? And I would add something today happened that was explosive that we still don't know what happened. We were supposed to go back in after lunch at 12:30, but we didn't go back into 2, which there's a question of what was going on within that time frame, because it was some energy coming out of that courtroom. And we were waiting to see if Hunter was going to testify, because the defense had the ability to call that brother, which he didn't. The state didn't call him, which we know he has a lot of credibility issues. But we were waiting to see if the defense was going to call Hunter. But after that lunch and that hour and a half break that added after that lunch, we are still trying to figure out what happened as to why both sides had this intensity about themselves coming outside of their courtroom.
All right, then. So again, closing arguments will be taking place tomorrow in that Collin County. And then the jury will get that case and decide the fate of Karmelo Anthony, of course, who is being tried for murder there in Collin County. Thelma Anderson, we certainly appreciate it. Thanks a lot.
Thank you.
Most significantly, the court demonstrated that an overflow viewing room was both available and workable, and then took it away. During jury selection, on June 3rd, 2026, the court provided an auxiliary viewing location outside the courtroom where members of the public who could not be seated inside could still observe the proceedings. The court did not merely provide this accommodation, it announced it in writing before trial. On May 29th, 2026, The court-appointed public information officer advised the public that media and general public will have an opportunity to watch a live feed of the jury selection process from the ceremonial courtroom with television monitors and audio provided, and that once testimony begins, the proceedings will take place in the 296th District Courtroom, following the same procedures. On June 4th, 2026, the first day of testimony, the court eliminated the accommodation and confined public access to the seats inside the courtroom, with no overflow room, no audio feed, and no video feed of any kind. The significance is twofold. First, the court's own use of an overflow room during voir dire proves that a reasonable and readily available alternative to exclusion existed, the very kind of alternative Presley required the court to consider. Second, the court did not merely fail to consider the alternative, it adopted the alternative and then withdrew it for the guilt, innocence, and punishment phases without findings and without explanation, narrowing public access precisely as the most consequential testimony began. Okay, you guys, so I'm going to stop right here and kind of explain this to you. So what Karmelo's appellate attorneys are arguing is that not only was there a reasonable alternative available, but the court implemented it and then withdrew it, which makes this even more damaging than if the court didn't even implement it at all. Does that make sense? So basically what they're saying is that the court did implement the alternative of an overflow room, but then without any sudden warning, people showed up and then the overflow room wasn't available anymore. And so what they're saying is that just cuts worse than if the court never even implemented it at all, right? So anyways, let's just go ahead and continue and see what else they argue. The reason a deputy gave members of the public for refusing overflow that the trial courtroom was the only one without video conferencing or Zoom capability does not withstand scrutiny. Defendant expects to establish at the hearing through courthouse administration and information technology witnesses, the courthouse space and technology were available to provide continued overflow or audio and video access. At minimum, the court's public statements thanking the other judges of the county and the county's information and technology and facilities department for their flexibility in meeting the demands of the trial raise a fact issue that the court was required to explore before withdrawing overflow access. The court had, moreover, already deployed an overflow room with a live audio-video feed during voir dire, establishing that the space, the equipment, and the personnel to provide it existed, and it acknowledged that an audio stream of the proceedings was feasible. The order's only affirmative public entry window, the 10 minutes between 8:50 a.m. and 9 a.m., proved illusory in operation. In practice, the limited public seats were claimed by a line that began forming in the pre-dawn hours, often between 4 and 5 a.m. Admission turned not on the entry time the order specified, but on how early a member of the public was willing to arrive and wait. A member of the public who appeared at 8:50 a.m., the time the order designates for public entry, had, as a practical matter, no realistic opportunity to be seated. The narrow window the order provided on paper was therefore narrower, still in operation, and for many members of the public, it was no window at all. The admission process the order set in motion operated without transparency or consistency. The order prescribed no method for allocating its limited public seats. In practice, admission was governed by an informal line in which some individuals were permitted to move ahead of others who had already waited for hours, so that a member of the public who arrived early and secured a place near the front of the line could nonetheless be displaced to a position well beyond the number of available seats. And although the order barred re-entry once proceedings began and made no provision for admitting waiting members of the public as seats opened, seats did become available during the trial as observers came and went. Yet, members of the public who had waited outside were admitted, if at all, only hours later after substantial portions of the proceedings had already passed. Nor does the order's provision for admission at a recess cure the exclusion. Admission at recess after the morning's testimony has been taken is exclusion from that testimony, and unlike the brief single witness exclusion in Williams, mitigated by a contemporaneous live feed, the exclusions here were mitigated by no feed at all. The operation of the order thus produced the precise harm its text foretold: members of the public excluded from significant portions of the trial with no contemporaneous means of access. Finally, the mechanisms by which the court administered and defended these restrictions operated off the record. A member of the public's request for an alternative viewing location could not be filed through the county's electronic system for a criminal case and was instead routed by email to a public information officer designated by the court who reviewed and denied the request outside of any judicial proceeding. No hearing was held, no evidence was taken, and no order subject to appellate review was entered. At the same time, the member of the public who observed these proceedings described no disturbance, security incident, or disruptive conduct by any member of the public that would explain the restrictions imposed. The as-applied operation of the order thus contains both halves of the defect. The closure was more severe in practice than the order's text, and the generic speculative findings ordered to justify it are contradicted by the conditions the public actually encountered. These conditions can be stated with precision because they recur across the sworn accounts of the members of the public who tried to attend, including the affidavit of Thelma Anderson and the accompanying declarations and the court-appointed public information's own email. The amended order addressed entry times, a 9-person media cap, space, available seating, and re-entry. It did not address and it did not authorize the following features of the closure that governed access to this trial in practice.
North Texas remains the center of national attention after the first day of jury selection wrapped up in the track meet stabbing trial. On Monday, nearly 200 potential jurors answered questionnaires about the case of Karmelo Anthony, a black teen who was accused of killing 17-year-old Austin Metcalf during a 2025 track meet in Frisco, Texas. Anthony is claiming self-defense. Attorney Thelma Anderson is covering this case for the Black Star Network. She joins us now from Dallas. Thelma, I understand there's no court today. Can you kind of walk us through what happened yesterday?
Yes, so yesterday, when I arrived to the court, I immediately went to the floor that is designated where jury selection was going to take place. Now, I do want to state that Collin County has, for security reasons, stopped trials or any other business that goes on in the court. So this case has received heightened security and has limited other courts' ability to do business as usual because of the security threats. Now, on the day of the first day yesterday, there was a crowd of potential jurors, but the public could not view jury selection, but they had holdover rooms in order for individuals who wanted to listen in. But as far as individuals are the ability to view what is going on during jury selection, you are not allowed to per the courtroom rules.
A cap of roughly 27 seats for the general public, a number the order never stated. An off-the-record allocation of the court's approximately 70 seats, 15 to each side's family, 9 to the media, and the balance to court staff, leaving only about 24 seats for the general public. The provision of an auxiliary overflow viewing room during jury selection on June 3rd, 2026, and its elimination on June 4th as testimony began with no overflow room, audio feed, or video feed of any kind thereafter. Admission governed not by the order's 8:50 a.m. entry window, but by a line that formed in the pre-dawn hours, often between 4 and 5 a.m., so that arrival time rather than the order's schedule controlled who was admitted. The absence of any method for allocating the limited seats producing an inconsistent and non-transparent line in which some persons were permitted to move ahead of others who had waited for hours, displacing members of the public who had arrived to positions well beyond the available seats. The administration of public admission and the denial of access by a court-appointed public information officer and county staff who described the process in the collective first person, we chose, we invited, we had no choice, rather than by the court in open court and on the record. A standardless media determination that permitted self-designated media to consume the public's limited seats. The routing of requests for an alternative viewing location by email to the public information officer because the county's electronic filing system provided no category for a criminal courtroom access request, and the denial of those requests outside any judicial proceeding, leaving no hearing, no evidence, and no order subject to review. An initial prohibition on bringing notepads or pens into the courtroom, later modified, a restriction on the public observation found nowhere in the order. The physical removal or turning away of individual members of the public, including the removal of a member of the public for the expressive content of her clothing, and the denial of restroom access to her minor son. a limit of 8 total seats for the defendant's own family, which excluded the defendant's grandmother and aunts from his trial, partial access, even for those eventually admitted, who in some instances were seated only in mid-afternoon after substantial portions of the day's proceedings had already passed. None of these conditions appear in the amended order, and none rests on any finding the court made or any evidence the court received. Assessed on the totality of the evidence, they establish that the proceeding was closed far more severely than the order's text discloses, and that the closure was neither narrowly tailored nor the product of consideration of reasonable alternatives the law requires. Okay, you guys, let's stop right here before we get into the next section. So, I've been pretty transparent when I say that if Karmelo and his team can show that all of this was in play, I think that's a hearty argument. I think that's a good argument. I think that's an argument that's worthwhile because Karmelo is entitled to a public trial. And if the court restricted everything to such an extent that even members of the public didn't even know what restrictions applied to them, I think that's valid. I think that's a good argument to make. I think they're making a phenomenal argument. And let's just go ahead and carry on and see what else they say. The order fails the Waller test at every step. The first Waller factor was never satisfied by anyone. The factor requires the party seeking to close the hearing to advance an overriding interest that is likely to be prejudiced. Here, no party sought closure. No interest was advanced by any proponent. And because the court took no evidence, no interest was shown to be likely prejudiced. The court's generic recitals cannot supply that showing, and a court may not relieve itself of the burden by acting on its own motion. To the contrary, in Presley v. Georgia, the trial court excluded the public from voir dire on its own motion, and the Supreme Court reversed precisely because a trial court must satisfy Waller and must consider reasonable alternatives, even when the parties do not propose them. The remaining Waller factors fail as well. The restrictions were broader than necessary, a fixed numeric cap on attendance, a 10-minute public entry window, and the categorical absence of any overflow accommodation swept more broadly than required to protect any interest the court identified. And the record does not reflect that the court considered any reasonable alternative, an overflow room with a closed-circuit audio or video feed, a larger courtroom, or staggered or reserved public seating, as Presley required it to do even on its own motion. The order's findings cannot bear the weight the Sixth Amendment places on them. The court did recite findings that the case has generated substantial public and media attention, and that unrestricted access or activity may compromise courtroom security, jury privacy, and the defendant's right to a fair trial, but findings of this kind are legally insufficient. They identify only generalized categories of concern, not specific, concrete facts or articulated threat that Waller and Presley require, and the word may confirms the court identified a speculative possibility rather than a demonstrated risk. The Court of Criminal Appeals rejected materially similar findings in Stedman, where even detailed findings of heightened security concerns and potential juror discomfort were held insufficient because they were generic and identified no specific threat or incident. Findings specific enough that a reviewing court can determine whether the closure order was properly entered are the linchpin of the Waller test, and generic findings will necessarily invalidate a closure. These findings are not only generic, they are unsupported because the court received no evidence. The court held no evidentiary hearing on the restrictions, took no testimony, and admitted no exhibit concerning courtroom capacity, security, juror privacy, or the risk of prejudice. Findings on those subjects made without any evidentiary basis rest necessarily on either the court's own assumptions or on information outside of the record, neither of which can satisfy the burden to justify a closure or support findings that the defendant had no opportunity to contest. That distinction governs review. An appellate court defers to a trial court's findings of fact only insofar as they are supported by the record, and findings without evidentiary support receive no deference. Nor may the deficiency be cured after the fact by post hoc assertions. The closure stands or fails on the findings the court articulated when it acted. And the order's own recital that it affords reasonable public access consistent with constitutional requirements cannot be reconciled with its operative terms, a 10-minute entry window, no overflow, and no live stream, which demonstrate the opposite. The court's post-trial interview supplies no cure for these deficiencies. There, the court suggested that the presence of minor witnesses justified limiting public access. That rationale appears nowhere in the order's contemporaneous findings, and a closure cannot be rehabilitated by a justification offered only after the fact. The adequacy of a closure is measured by the findings the court articulated at the time, which must be specific enough that a reviewing court can determine whether the closure order was properly entered. The rationale fails on its own terms in any event. The Supreme Court has squarely held that even the compelling interest in protecting minor victims of sexual offenses, a more sensitive concern than the mere presence of minor witnesses, does not justify a rule of mandatory closure. Protection of a minor must instead rest on a case-by-case determination, supported by particularized findings that exclusion is necessary as to a specific witness. A generalized concern for minor witnesses could therefore support, at most, a narrow measure addressed to particular testimony, not a fixed seating cap. The elimination of overflow and the denial of any live stream across the entire trial, Texas law confirms the point. Even in juvenile proceedings in which a child stands accused and faces adjudication of delinquent conduct, the court shall open hearings to the public unless the court, for good cause shown, determines that the public should be excluded. And only for a child under the age of 14 must the court close the hearing, and then only unless the court finds the interests of the child or the interests of the public would be better served by opening the hearing to the public. If Texas keeps open even the proceedings in which a minor is the respondent, the presence of minor witnesses cannot warrant closing this adult criminal trial to the public as a whole. Okay, you guys, let me just stop right there and explain it to you. I'm going to explain it by comparing this case to David's case, okay? Remember David's case? And do you guys remember how we were talking about how Celeste was a minor under the age of 14 when all of these alleged sexual assaults occurred, right? And do you remember me telling you that I wouldn't be surprised if, after all the continuances, David decided to waive his right to a prelim? But should he proceed to prelim, I wouldn't be necessarily surprised if the court closed it down, right? Because she's a minor under the age of 14. Got it? Got it. So under certain circumstances, the court can limit access to public proceedings. And what they're arguing is, okay, well, if in sexual assault cases where minors are the victim, depending on the age of the minor, that is not necessarily an automatic closure of a proceeding. How can we say it's an automatic closure for minors just being witnesses in the trial, not the victims? Does that make sense? Finally, the order applied the wrong constitutional standard. It characterizes the restrictions as reasonable time, place, and manner restrictions, the standard that governs the regulation of speech in a public forum. That is not the standard for excluding the public from a criminal trial. Reasonable measures that merely administer the courtroom may be permissible, but the provisions that exclude the public, the 10-minute window, space available seating behind the media cap, the no re-entry rule, and the absence of any overflow affect a closure governed by Waller and Press Enterprise, not by the more lenient time, place, manner test. By treating an access closure as a time, place, manner regulation, the court applied a less demanding standard and bypassed the findings Waller requires. The order's reliance on Shepard v. Maxwell does not assist. Shepard concerns a court's duty to control prejudicial publicity and press conduct to protect a fair trial. It does not authorize excluding the public from the courtroom. A standing order is no substitute for an open courtroom, and every reasonable alternative was ignored. The form of the court's action independently offends the public trial guarantee. The restrictions were imposed not by case-specific evidence-based findings developed at a hearing, but a preemptive written standing order. The amended order regulating trial proceedings adopted in advance to govern all aspects of the trial proceedings. The Office of Court Administration, in published guidance grounded in Waller and its Texas progeny, has explained that no standing order or global rule for closure of specific categories of hearings may preemptively be issued by a court without running afoul of the requirement to provide the public with access to court proceedings. Because the court must instead consider all reasonable alternatives to closing proceedings and make findings in open court on the record adequate to support closure, weighing the totality of the circumstances, Office of Court Administration, the court standing order did precisely the opposite. Okay, you guys, we're kind of going really, really deep into this. I am trying really hard to read the entirety of this whole document to you guys, but go ahead and let me know if you're still enjoying this. If you're not, we can move on and you kind of get the gist of at least this first argument. But I think at this point, counsel is kind of reiterating itself quite a bit and saying the same thing. So there's no need for us to keep going back and forth on it. And we're not going to do that, at least not in this video. And I can continue next video if you guys let me know that you're enjoying it. So that's where we are so far. Let me know your thoughts on this video and let me know anything it is you want to let me know down. Pause. Pause. If you guys enjoyed this video, go ahead and let me know. Don't forget that I have memberships now. If you want to join and become a member of my channel, you can get videos like these and videos that you enjoy a little bit earlier if you become an Esquire specifically, okay? I think that level's like $4.99 a month. Okay? Got it. You can also show me your appreciation just by liking the video, commenting, joining my channel, subscribe. Literally subscribe. That's all I'm asking. I enjoy talking to you guys and I hope you enjoy listening to me yap. As always, thank you guys so much for watching. Please be sure to like, comment, share, and subscribe. Until next time, y'all take care.